Absolutely happy to do it, and I appreciate that intro. Hopefully, I can step up to the bar you set there. The esteemed and all those extra titles you gave me, makes me a little nervous to step up to it.
I wouldn't have given them to you if you hadn't already proven that you earned them. So I think we're on. I have no doubt that you're gonna impress there.
I appreciate
Just
it.
a reminder, just a reminder to everybody who's watching, we will be providing a replay of this video. So if you don't catch something and you need to rewind, don't worry. As long as you registered, it will be in your inbox by the end of today. We will also be posting the video on YouTube. I believe Mark will probably also push it out to his socials. So no matter which one of us you follow, hopefully it's both of us, you'll have an opportunity to review the content for a second or a third time. One of the things that we are changing for today, we are no longer doing an open chat. Instead, you'll see on the bottom right, if you do have any questions for the Q&A portion at the end after we've kind of gone through our interview, please just text the questions to the number that's on the bottom there, 904-930-4490 or 4490. Yes, that is the right number. I promise you will not be signing up for spam. We will not be calling you out of the blue, right? It's just a slight technology change in terms of how we digest that information. Before we get started, Mark, I know you said you just wanted to mention something real quick on a legal disclaimer. Want to make sure we give you a couple seconds to do that.
Yeah, no, I appreciate that. And it's kind of one of those, what kind of attorney would I be if I didn't give disclaimers and have the fine print and the red tape? Kind of like, the financial professional like yourself, but just want to put it out there that all of this is for educational purposes. None of this is legal advice. Everyone's situation is different. Yes, you may be similar in the sense that you may have a need for a supplemental needs trust or a special needs trust, but the nuances of that are all different. So that said, don't take this as legal advice. Don't act upon it. Contact an attorney, whether it's myself, another attorney. Speak with an attorney to make sure that what is said and what you want to do aligns with your plans and your goals.
See, I know you were the right person to do this with because I could actually understand you. You didn't read that at 300 words per minute like they do on the radio. So, right, even the disclaimers are coming across better and of higher quality than we're used to. So we're going to run right into it because I know we're probably getting people right in front of their lunch hour for those who are joining us live. Could you describe for us just real quickly, high top, what is a special needs trust?
Yeah, so a special needs trust, supplemental needs trust, SNT, there's all different names, variations, different flavors, if you will. I don't want to go down that rabbit hole yet, but on a high level, a special needs trust is a way for individuals with developmental disabilities that are receiving government aid to receive assets and maintain that eligibility. So typically, for some of these government programs, you can't have more than, let's say, $2,000 in assets. Let's put the income aside. And if someone passes away, you are set to receive more than $2,000. You can't without jeopardizing these benefits. So a special needs trust is a way to kind of marry the two of those and have your cake and eat it too, and receive those assets indirectly. And I'm sure we'll get into that when I say indirectly, but it's a way to receive the assets, but not lose or jeopardize the eligibility for those benefits.
Okay, so kind of, I know this from working in financial services, but I know a lot of people don't. They hear trust, and some people think trusts are a monolith, and in fact, they're not, right? There's all different types. So probably the other type of trust that most people are familiar with would be a living trust, inter vivos trust, like the type of thing that you would, use to just wrap other assets. Can you discuss some of the main differences between a special needs trust and that living trust that most people are familiar with?
Yeah, so I like to say that trusts are kind of like Baskin Robbins. There's 31 plus different flavors and types, and even more so that are being created all the time. Some major differences with a revocable living trust. Let's say, Brian, that you create a revocable living trust. You are a grantor and could be one of the initial beneficiaries during your lifetime. You are able to control those assets. You're able to demand, if you will, make requests that you receive assets. With a special needs trust, that ability to demand payment is not there. That ability to control what money is used for is not there. One of the biggest reasons for that is to maintain, again, eligibility for those programs. If you have the ability, if you are a beneficiary of the special needs trust and you have the ability to say, hey, Brian, I need $1,000, I need $5,000. In essence, those assets are in your control, they're in your possession. The government's going to say, good try, we're not going to look at it that way. They have to be outside of your control, and you can't demand or request payment. So that's one of the major differences, is the lack of control for a beneficiary to make demands or requests for payments, and control to a certain extent what the assets are used for.
Okay, perfect. I think that does a really good job of kind of telling people why a special needs trust, as opposed to, just a typical living trust or any other, the 31 flavors, as you mentioned. I guess, so that kind of leads us to the next question, though, is let's say that you are a family with an individual with special needs, and you're not currently receiving government benefits, or maybe you don't anticipate receiving government benefits. Could you still utilize a special needs trust? Would that be appropriate, or maybe is there another avenue to go down?
You could utilize one still. I can't say 100% if I would recommend that to a client of mine, to have a standalone special needs trust if they're not receiving benefits, if they don't anticipate ever needing benefits. But what we do often is, in the planning that we do for the parents, grandparents, whoever the guardian is, we can include language in their last wills or in their revocable living trust that we set up that has sections applicable to a special needs trust. So if one of the beneficiaries uh, becomes eligible or needs to start receiving those benefits, the assets that go to them won't go outright, and they are kind of compartmentalized, if you will, and applicable and governed under that section related to the special needs trust. So we can do it that way, but I would be hard pressed to recommend to a client that's not already receiving benefits or does not anticipate receiving benefits to frankly spend the money to set up a standalone special needs trust if it's unlikely that they think they'll have a need for it.
Okay, and we're big fans of doing what, not necessarily whatever the crowd is doing, right? It's what's doing what's best for the individual client, what's doing what's best for the family. I know your office is the same way, so I think that's probably something that is not usual to hear, but really important. Hey, just because you have a child with special needs trust, right? It doesn't necessarily mean that you need the trust. Maybe another vehicle, another avenue. Um, let's talk real quick about the process to create a trust. So, everybody has a different idea of this until they go through it. And I'm sure, every attorney is different, every attorney office is different, but take us through the process at your office. What does it look like when somebody comes in day one? Hey, I've got a child with special needs. I'm thinking about a trust.
Right. So there's a few different roads you can go down, and I want to go back, and again, the rabbit hole I said I wasn't going to go down when we talk about the different flavors. I'm going to backtrack now, of course. Special needs trust, there's two main differences. You have first party, third party. Third party is the most common. First party is much more rare, but it does occur. The biggest difference of third party is, let's say Joe sets up a trust for Joe's child. That would be a third party special needs trust because it's Joe's assets being utilized for the trust for the child. If, let's say, Joe as an adult is receiving government benefits and then he has a recovery in a lawsuit or inherits money, and wants to maintain eligibility, that would be a first party supplemental needs or special needs trust where it's Joe's assets used to put in there. So as far as the process goes, depending on if we're looking at a third party, first party, the timeline of those being established could be different, mainly because a first party could be, if it's from a lawsuit, the other lawyer might be holding a check, the client could be holding a check. We may have to get this done right away within that same month to maintain eligibility. So that could impact the timeline. But generally speaking, and for a third party special needs trust, the usual process, let's say someone calls in, I think I need this, I'd like to have a consultation. We will send them a questionnaire. They'll fill that out. We'll set up a complimentary consultation, walk them through kind of our recommendations, learn more about their goals, what they need, and then start drafting. The whole process from start to finish, generally speaking, is about 6 to 8 weeks, which some people think is quick, some think is too slow. If it's TV, it should be done in 22 minutes. Could I get something done that quickly? Probably. Is that something that I would want to get done that quickly and then give to a client? Absolutely not. And part of that reason for that 6 to 8 weeks not only is for my office, but also for the client. These are things that they may have heard about. You and your office may have spoken with them about, but there's a lot of other things going on in their life. And these are not things that they think about, deal with day in and day out like you and I do. So they need time to process, and is this the right thing? Is who I have as primary or successor trustee the proper person, or do I want that to be different? What are the terms? Those sorts of things. People can make that decision on the fly, but once they go to sleep at night and think about it, is that really what they want, or do they want some time to really sit on it, let it sink in, and make sure that's what they want?
Yeah, I mean, I think this probably legal profession probably is the least benefited by Law and Order managing to do an entire criminal investigation and prosecution inside of 42 minutes. So good things take time, right? Good things aren't fast. Fast things aren't necessarily good. And I think that's 6 to 8 weeks from our perspective. When we talk about building a special needs plan, it's usually right around that time frame, right? And so those are two processes that sometimes run in parallel. Sometimes they're done in sequence. But it's doing it properly is more important than just getting it done quickly in most cases. I will say so one of the questions we get a lot from people, and so I included it to ask today is, we have some families who know they have a child with special needs at birth, or in some cases even earlier these days. You have some where a special need or a disability develops as a result of an accident, of a flashpoint in time, much later in life, in some cases decades. When should an individual think about establishing a special needs trust, right? And we can look at those two different scenarios, right? We can look at one where disability since birth versus disability as an incident, but is it absolutely got to have it right now, or are there flashpoints that we need to look at?
There's flashpoints. It's something that, like everything in life, and I think it's the financial world really clings to this quote, something along the lines of the best time to plant a tree was yesterday, and the next best time is today.
You stole my favorite quote.
I may have, I knew you. Financial world really clings to it, and I like it as well. I don't want to say it's never too early, but obviously, if you learn of this and you are still holding child is not yet born, probably a little too early to set it up. But basically, anytime child is out and alive, if you think there's a need for it, set it up. It's one of those things, just like life insurance, just like disability, everything out there. It's better to have it before you need it, because once you need it, in this situation, it's not that you can't have it. I've had some cases where someone's passed away and a beneficiary was receiving government aid, and we were able to quickly set up a trust to protect those assets utilizing the special needs trust as well as ABLE accounts to protect those assets. But that was kind of a burn the candle at both ends, get it done quickly. Obviously, the more planning, the more time we can have, the better off, in my opinion. So yes, there's flashpoints, but it's one of those, when you think about it, when you have some time, that's when you want to address it.
And we'll talk about some of the more specifics in later questions, but just to be perfectly clear too, setting up a trust doesn't necessarily mean that it needs to be funded, right? I mean, I don't know how many of these you've drafted. I've reviewed dozens, and usually in most cases they're opened with a small nominal fee, because the goal is just to establish the trust, not to sock a 7-figure number away, when a child is
Correct.
2 years old.
Yeah, I mean, if someone has the ability to write a check and put 7 figures away when someone is 2 years old, I mean, one, congratulations. Two, are they looking to adopt?
You, right? You
yes,
personally?
yes, adopt me. But all jokes aside, very rarely do we have a situation where someone can show up a check and fund it, whether it's 7 figures, whether they've had a cost of care plan and had that and know how much they need to put in it, or they put a couple thousand, even $100. It's rare that we have large sums go into it. Typically, It's, the proverbial $10. It's open. It's something there. So now it's in existence. If grandparents, aunts, uncles, other family members want assets to go to said child or individual, they can, and now they just change it to go to the trust. So it's easy to do. You want to have it open, but very rarely do I have clients that can just stroke a check. 9 times out of 10, that's where we work together so well. Is my office, we set it up, we put the framework in place, hand over to you. You figure out the cost of care. You have those calculations. I don't. The cost of care. What are those needs? What's the best way to fund it so that when death, disability of the caretaker occurs, money is there so that that individual can still receive kind of continuity of care.
Yeah, and I think what you just said is really important, because one of the first activities that we do usually with special needs planning is we'll ask parents, caretakers, go through your beneficiary list, right? And not just, in your will or in your maybe personal trust that you have, but look at insurance policies, right? It's one of those areas that a lot of people overlook. You can't name a trust as beneficiary of an insurance policy if the trust doesn't exist. And so that's kind of one of those things where you can't put the chicken before the egg, or cart before the horse, whatever your preferred farmhand analogy is. And, some of these things do have to be done sequentially. Let's talk about, so we just talked about putting $10 into a trust. Obviously, I think everybody knows, right? Liquid cash can be held by a trust, but what are the types of assets can a trust hold? We get this all the time. Can it hold house? Can it hold insurance policies? Right? Not necessarily what should it hold, but what can it hold?
To me, it can hold anything. There's really no limit on it. The real limit, again, is what can it be used for? And that's where, again, you get the name and they're used interchangeably. Special needs trust, supplemental needs trust. It's there to supplement the needs of that government benefit. So if Medicaid, SSDI, if these benefits are paying for housing, if they're paying for food, the trustee really has the obligation, and they have to know what they can and can't do, typically along with an attorney. Take with a grain of salt. Yes, that's what I do. But we want to make sure they're doing it properly. So they really need to know what they can and can't do, because if they spend money and use money for the beneficiary's benefit, and that's something that Medicaid would have already paid for, everything now could be in jeopardy. So to me, there's not a limit on what the trust can hold as much as what can the assets be used for. I have clients where when we set up the planning, we will set up assets to funnel into the special needs trust, as well as a portion of the real estate. Let's say, for example, parents own, their primary residence, their homestead property. They want it to be split between both of their children, one of which, however, is receiving, means-based aid, and they don't want to jeopardize that. Well, we have half of that property go into the supplemental needs trust at the parent's death. So now that individual owns, via the trustee, that 50% of the property. The property is sold, no problem. Money's in the trust, it's protected. It's not a countable asset for the beneficiary.
So I think the most important thing to take away from that, right? It can hold pretty much anything, right? Which, again, that's a question that we usually get. I will say that the extension of that is, what should the trust hold? I think that's, not to take anything away from the back and forth, but typically ball falls more in our court, because what we love to see is liquid, easily priced, right? Very easy to distribute. Homes are great, but anytime you want to use it to fund something else, you got to sell it first. That comes with costs and time. And so a lot of the things that we talk about with clients is not just what can the trust do, but a lot of times what should the trust do. That's for a separate webinar, but just in case anybody watching this goes, I'm going to go put my house inside of a special needs trust right now because they said we can, we want to make sure that we caveat that.
Right. Again, that goes back to the initial disclaimer of this is all educational. Don't necessarily take it as legal advice. But what you said, Brian, yes, and that's the back and forth and the relationship that we have. I can't, and frankly don't want to touch the assets and the funding. Again, there's a huge difference. We both have young or younger children. there's a big difference, the life lesson of between can and should. Huge difference. So just because it can hold all of these assets from your perspective doesn't mean that it should. And again, every person's situation is different. This client that I'm talking about here, they know that the house is going to get sold, but they want to make sure that 50% of that goes to one of the children. This is the most efficient way to do that. And then it becomes a liquid asset that you can, as you said, is more easily accessible, distributable, and frankly, investable for you guys.
I can hear our mutual compliance people praising our abilities to make sure that everybody knows that each situation is individual and needs to be dealt with specific to those individuals' needs, which is good because you always want to make sure you're staying on the right side of that.
Yes, all the compliance ears listening somewhere.
We love you and thank you for the work that you do. So you mentioned very briefly kind of the trustee and their role and their responsibilities for distribution of assets. Can you touch, so this is a two-part question, right? Because I'm sure this is another question that you get all the time. One, can you talk about what the generalized responsibilities of the trustee are, right? So you've already touched on some of them, but then two, what's your capacity to act as trustee? Because I'm sure I'm not the first person to ever ask you that.
Yeah, so I'm going to hit the easiest one first as far as my capacity to serve as trustee. Again, we talked earlier about the can and should. Can I or can my office serve as trustee? Technically, yes. Will we? No. Reason being is, again, we're here to practice law, not to handle necessarily the trust administration. So if we're doing that, no question about it, we're going to charge a fee. That's not to sound disingenuous or lawyers are always after money or anything like that. It takes time to do, and there's attention and detail that's needed. So we won't serve as trustee. There are plenty of professionals out there that we have great relationships with that will serve, and I know you have those as well. And frankly, a lot of situations with clients, I will encourage those professionals for the primary reason that oftentimes, let's say that situation where you have two children, one has the needs, one does not. Parents will kind of instinctively want to have the neurotypical child serve as trustee. Can they? Sure. Where I have the apprehension is, will they have the time, the ability, and frankly, the desire to want to do that? There is sometimes an underlying, I hate that I'm saying it, but it's just the reality of it. Sometimes there is a jaded perspective of things are always focused on my sibling and not on me. And now I'm in control. And it's more of my energy and time. So it's keep that dynamic out, let them be siblings, let them spend time together and not have that obligation. So professional is often recommended there. And the other one, as far as the trustee's duties, they really have, you treat it like a typical trust administration. And then they have the trustee's duties as far as reporting with Medicaid, those other institutions, and the distributions. Those are the biggest things, and knowing and learning what Medicaid and these other benefits cover and what they don't, to ensure that you are not taking steps to jeopardize those assets and now lose the benefits. Because that is not a fun place to be at all.
No, it takes a monumental effort to get them. I've never seen anybody personally lose them and be able to recapture them, right? And so I don't think anybody wants to put that in jeopardy, especially if you're a parent. You think about what happens if they lose them and I'm gone, right? And they lose their typically their biggest and best champion. The scenario that you played out with the siblings is an interesting one, and it's always one that we bring up because even in the absence of malfeasance or the sibling wanting to do something that's nefarious or might have that degree of negative kind of involvement, right? You never know what situations the sibling is going to be under, whether it's they marry somebody who might not necessarily fully understand the circumstances, right? As a former naval officer, I deployed. So if I was a trustee of a special needs trust, I'm gone for 6 to 7 months and can't be the one who's physically doing it, right? There are so many different scenarios where even if a sibling is trying to do the right thing, they may not be capable or might not be available. We always encourage, right? You mentioned we have partners. We always encourage people seek out a certified trust fiduciary advisor, right? A CTFA. That's kind of the epitome of a trust advisor's credentialing. Typically, it takes decades to get that certification in terms of experience. And so somebody who, as you mentioned, knows the ins and outs, lives and breathes it every day, gets paid to do the work, and is, in our opinion, usually the best scenario for a contingent trustee once the parents are gone. So that kind of tipped out the, who or can or should be named as trustee. I will also mention, right, if you do have two children, one with needs and one without, a great role for the sibling, if they want to remain involved but not be the trustee, is the trust protector. I don't know if you can speak a little bit to that, just about what that role is, maybe how it differs and how that can allow for sibling involvement without that day-to-day grind.
Yeah, and there is, and I was going to bring up a trust protector. There's various different levels of involvement and scope of authority, if you will, that you can give that sibling as a trust protector. But they essentially, and you mentioned, and I like the way you phrased it, the parents are typically kind of the best advocate. It empowers that sibling to almost step into that place and be the best advocate, and they are kind of the check and balance on the trustee. They don't necessarily have the authority to tell the trustee what distributions to make, but they can be a sounding board and double check different types of investments, different things that the trustee is doing, and they often have the ability to replace the trustee where the beneficiary, again, for the reasons I mentioned earlier, would not have that ability and authority. The trust protector would. So it allows them, again, instead of saying, okay, sibling, you have all of these responsibilities in addition to everything else you have going on, it says take a step back, be there for your sibling, care for them, love them, advocate for them, double check the trustee, but you don't have the obligations and duties that the trustee does, but just be there to double check and make sure that your sibling is being cared for and nothing nefarious is happening.
And I will say that the additional reason to bring in a professional, right, and this is just occurring to me, is that siblings are mortal as well, right? And none of us know when we're going to step off the curb and there's a bus coming. But corporate trustees, right, corporate contingent trustees are technically perpetual. And so the idea of there being somebody where there will always be somebody there to facilitate that trust, regardless of how long the beneficiary needs to live, is also really important, because we do see a lot of incidences where somebody passed prematurely and it kind of throws the best laid plans up in the air. And we obviously don't want to see that. We want to see the plans be as smooth as possible when it comes to execution. Just a reminder, so we're reaching kind of the end of our prepared, back and forth. So if anybody has any questions, please feel free to text the number below, 904-930-4490, and we will address those. I guess, Mark, this is kind of the point where anything you think we haven't covered that you desperately want people to know about special needs trust. I think we hit on what it is, differences between first and third party, right? Why you need it, what you can put in it, when you should build it, and who should run it. As far as I'm concerned, from the financial perspective, we've hit all of our high points. I of course always yield to you in a legal context, because law school is not something I'm interested in doing.
No, so I appreciate that, and that's also the reason why I'm only licensed in Florida and I've not sat for the bar in any other states. At least at the time of this recording, is I don't want to go back and do that again. It was hard enough the first time.
But you caveated it as of the time of this recording, so
I don't want to close doors. I'm not thrilled about the idea of doing that, but I also want to keep my options open. So when things are recorded, you have to leave those outs. As far as other things to know, I think we've covered a lot with special needs trust, and I don't want to get too overwhelming or into the weeds. But another resource and option that's there that I don't know if folks may not necessarily know about or don't take advantage of and use are ABLE accounts. We often use ABLE accounts in conjunction with special needs trusts. Again, we don't manage them, we don't fund them, we can't and don't give financial advice on them, but those are great resources and tools for individuals with disabilities that might need to sock money away and not have it counted as an eligible resource. So I don't want to get too into those, but those are a great resource. And the other thing to always think about as well, you talked about a contingency and making sure that things work smoothly, is making sure that there is a guardianship, or in Florida with someone that has intellectual developmental disabilities, a guardian advocacy in place. Because if someone has disabilities, and once they turn 18 overnight, mom and dad, as the typical best advocate there is, no longer can advocate, no longer can go back into doctor's offices, can go back into appointments, because that individual, as an 18-year-old, is an adult. Even though, as neurodiverse, they may not function at that same level, they may still need assistance. At the age of 18, mom and dad are out. So we need to make sure that there is a guardian in place that can advocate on their behalf. And when mom and dad pass away, who is that next person? And it doesn't have to be the same as the trustee. They can manage the funds, but who's going to manage day-to-day care? That can be the guardian. So those all kind of go hand in hand.
It's almost like you're reading my text messages, because we did get a question on guardianship versus trust. So very apropos. I think you already kind of labeled it nicely, right? But two separate processes can even be two separate individuals for two separate purposes. So very important to understand that, setting up a trust does not mean you have a guardianship arrangement. Setting up a guardianship arrangement does not mean that you have a trust. I'm assuming clients could do both of those simultaneously if they went through you and knew they needed both.
Correct. Okay. We do them simultaneously. And sometimes people don't even know that they need both, but during the consultation and our conversations, we'll bring it up, and we can kind of do it in a different phase approach. And whether someone is neurotypical, neurodiverse, even neurotypical, we can separate and bring that up as far as, if you have minor children, who do you want to raise them? Who do you want to manage the funds? Because some people are very fortunate, and there's one person that's great at nurture and nature. And that's kind of the nature nurture debate and conversation I have with clients is, this person may be great with money, but they can't raise anything that is dependent on them. This other person can't, manage $1 to save their life, but they are fantastic at caring for anything and anyone. Well, I want my kids with this person, not with this person, but I want this person to manage the money. So you can always bifurcate and separate that out. And now there's kind of a check and balance on those two jobs.
Yeah, dividing the labor to who's most suited or most aptly suited. I think we talk about that with clients even outside the special needs community, right? It's like, hey, listen, we talk about it with business owners all the time. You built a great business. That doesn't necessarily mean the best way to set yourself up for retirement. So let's make sure that we're putting the responsibilities in the right area. We got flooded with questions as soon as I said that. So we'll go through these in sequential order, in the order they arrived. Can we talk about linking a trust to an SBP, that's Survivor Benefit Program, from the military? I don't know how much experience you have with this. I know that from my experience in the military, that children with a disability that was diagnosed prior to 22, if the child was a full-time student, or 18 if they are not, right, they're considered to be an eligible beneficiary for the purpose of the SBP. So I would assume it's just a function of assigning the trust as that beneficiary. And then, unfortunately, I'm going to say this, probably having to take the paperwork down to the Personnel Support Detachment, PSD, at whatever your closest base is, NAS Jax, Mayport, if you're joining us in Jacksonville, and walking them through, hey, this is what I just did, make sure it's correct in the system.
Correct. And I would say that is more of a function when, we have some clients that want us to fund the trust for them. Majority of clients say, look, I can handle this. I can update beneficiaries. I can call Brian. He can make sure that it's done properly. Bank accounts, PODs, TODs. Great. That's, not necessarily what we're doing, but is, as you said, it's just a simple function as far as linking, just updating the beneficiaries to the trust. But I always recommend and encourage clients, once that's done and you're told, yes, it's complete, get confirmation in writing, typically on that institution or agency's letterhead, so that when the inevitable happens and the trustee goes to collect the benefit, that institution or agency can't say, well, sorry, it wasn't done properly. Well, actually, ma'am or sir, here's a letter from your institution or agency confirming that it was done. So please explain why 30, 40 years down the road, you're not telling me that it wasn't done properly. So always get that written confirmation.
And for whoever asked that question, I apologize because you're coming across as numbers, not names. That would mean getting an actual letter from DFAS, the Defense Finance and Accounting System, right? So they will absolutely send those. I have seen them, but you do have to ask and be a little bit probative. Next question. If the trust protector cannot say what to do or not to do, what, if any, recourse do they have if they see something they are concerned about?
So they aren't the actual decision maker like the trustee. They can't say sell Apple, buy Tesla. Not investment advice, just picking big names that I can think of on the fly. They can't do that. But if all of a sudden they see the trustee is selling Apple and buying whatever new Reddit meme, Bitcoin stock there is, they have the ability to step in and say, wait a second, trustee, this is not prudent. This isn't, there's statutes, there's obligations. The trustee acts as a fiduciary. There's certain things they can and can't do. You can't sell 80% of the trust assets and invest those in a highly risky asset and think that that's the best interest of the beneficiary. So the trust protector at that point has the ability to say, wait a second, you have X number of days to fix this, or bring a lawsuit on behalf of the beneficiary. So that's, again, where they come in as the advocate as opposed to the decision maker.
And to be perfectly clear, right, at least from a financial perspective, because we touched on the investment side of things, we always use North Korean equities for those things that are like so risky you shouldn't buy them anyways, because I'm pretty sure the State Department won't even let you. Not 100% sure, but I'm guessing. A special needs trust typically has a very conservative investment mandate because you're planning to have those funds available for decades. So that is something that should be discussed well in advance of any actual investment that happens, right? Is, hey, let's sit down and we're going to talk about the investment policy. So realistically or hopefully, right, there's conversation going back and forth, and you're not just seeing a drastic change like something fell off of a cliff and all of a sudden now you have to bring a lawsuit. It's probably, I'm going to pick up the phone and I'm going to call and I'm going to say, what are you doing and why, and get some justification. And realistically, right, you fire somebody if you don't like the work that they're doing, right? Or if you have to, you sue them. But you definitely do have options as the trust protector. That's why the role has been established. Next question is, if your child has an unused 529 plan, should it be transferred to a trust? This one, I think we kind of have multiple angles that we can hit on, because what I would say is if your child has a standard 529 plan, right? So college prepaid or, college savings, the easiest thing to do would be to roll it over into a 529 ABLE plan, which you are allowed to do with no tax implications. You can only do it based on the annual contribution limit per year, right? Which is, as of this year, it's $18,000. But that is the easiest way to handle it. And as long as the 529 ABLE doesn't eclipse $100,000 of total assets, it won't count against any government benefit eligibility. Now, Mark, I don't know if you have experience with somebody who might have more than 100,000 looking to transfer a 529 plan into a trust.
I've not had that personally, but I'll be honest, a lot of that, if I have someone that comes to me and says, look, I have $250,000 in here and I want to roll it over, I'm going to say, okay, that's something that we can do, but first and foremost, let's bring in your financial advisor and let's have that conversation, because I'm not licensed for it. This is one I can say unequivocally, I don't want to get licensed for that. I don't want to do those things. I think, and I have other reasons for that. That's, my own thing, but I want to deal with the other professionals. I like to stay in my lane, what I know, let them work with what they know, and we all work together for the best interest of the client.
And as the financial professional who suffered through the licensing process for that, I can appreciate that, right? But there are a lot of different options for things that you can also use a 529 for that many people aren't explicitly aware of, right? A 529 can be used for school tuition prior to undergraduate, right? You can use it for private high school or private middle school. So, if you have a child who's relatively young, who is going to be inside of a private school facility, right, that might be an alternative way to spend down those funds. We talked about a transfer. They can always be withdrawn, subject to penalty, of course. Again, reason why individual circumstances matter. But there's a lot of different things that you can do. It probably depends most on, what the specific circumstances are. Let me make sure that we got all of the questions. I think we did. We did. All right. We were trying to get this in within 45 minutes. We got it in within 42, so I feel pretty good about our timing. But just want to give, Mark, thank you again, right? Just a font of knowledge for us on this topic that we know pretty much every special needs family is going to at least discuss at some point, right? Whether or not it becomes germane, whether or not it actually comes to fruition. We just got one more question and we have 3 minutes, so I will take it. I feel like I'm trying to do my best AM sports radio impression right now, and I'm probably failing. I apologize to the audience. This individual asked, what are the acceptable distributions of a special needs trust? Is it only housing and food that are not acceptable distributions?
Typical legal answer is going to be, it depends. And I'm hesitant to give black and white answers because, again, the rules can change. But the easiest way to think of it is if the government benefit or program pays for it, that's a no-go. So if Medicaid is going to pay for some food, housing, no, you can't use it for that. And I've had other peers that have had clients that are huge sports fans. Medicaid is not going to buy, for example, season tickets to the Jags. There's just no way that's going to happen. If the beneficiary is a huge Jags fan and that brings more joy to their life and increases their happiness, go for it. Absolutely. That is something you can do. It's not a benefit that the government is going to pay for, so you're fine doing that. Kind of your haircuts, maintenance, care, those sorts of things, go for it. But as they mentioned, kind of housing, food, I don't want to say unequivocally no, but a very high level of steer clear of that unless things change.
I will say one of the strategies that we have seen work very successfully is that because that special needs trust is meant to be supplemental, right? And you can't use it, right, for food and lodging. One area or one account that isn't nearly as restricted is the 529 ABLE account, right? 529 ABLE, you can pay for anything that's considered a qualified disability expense. And the definition for that, I'm not going to bore you with the IRS regulation, but if you go, it is sufficiently broad as to include pretty much everything, including supplemental housing and food payments. So one of the things that we see clients do a lot of times is they'll have their special needs trust and it'll be funded and it'll have the vast majority of their resources. And then they'll have an ABLE account, and you can transfer funds from a trust to the ABLE account and then make payments from the ABLE account out to a vendor that maybe wouldn't have been acceptable straight out of a trust. So like Mark said, it depends, right? The circumstances are different for everybody, but I'm the same way. I'm never going to say you can never pay for that. It's a question of how can we figure out how best to pay for that? Because like everything else, right? The government doesn't want people not having sufficient food or housing, right? The government just doesn't want people taking advantage of the benefit programs. So if you can find a way to provide that without taking advantage, it's going to be permissible. So some food for thought later. I'm now going to wrap up because we're at 11:46, so we went over and we're bad people. But I'm just kidding, we're not. But thank you again, Mark, for joining us and bringing that legal knowledge that I think everybody who's watching this and hopefully everybody who watches it in replay is going to significantly appreciate. As a reminder, because I have gotten this a couple times, this will be available for viewing, right? If you're watching this right now, you will get a replay link, usually by the end of the day. Once we've put put it to bed and edited out all of my, ums and things like that. Kidding, we won't do that. But if you have any other questions, feel free to direct them to us or to Mark, right? Depending upon who you came here with. If you don't follow both of us already, please follow us on our socials, right? We both have Facebooks. We both have LinkedIn. I think Mark is on TikTok. I'm not brave enough. but I know he is there. I told you were going to dance at some point. I knew it was going to happen. But thank you, everybody, for joining us. Thank you, Mark, for being here, and we'll see you next month.
Perfect. Thanks for having me.